What happens after an arrest in Wyoming? This is Christina Williams with Just Criminal Law.
And David Mann, legal storytelling specialist. Okay, I'm sure everybody would really be interested in this. So what's the first few things that happens in the first 72 hours?
Well, the person is arrested and they're told what they're charged with. They're booked into the jail, which means that they have to submit to fingerprints, a mug shot is taken, and then they are set to go before the judge. And they are supposed to have a bond hearing and an initial hearing within that first 72 hours. Now, this doesn't always happen. It's not, it's definitely what they need to do legally, but that doesn't mean it always happens. So sometimes we get calls where people have actually been in jail more than 72 hours, and then we expedite the process by letting the prosecutor know, hey, we're going to represent this person. Why haven't they been before the judge?
So is there any consequence, to the court, I guess, or to the state for keeping somebody too long?
Well, they, they're not supposed to, and there is not really a consequence. If push comes to shove, we can demand that the person be released. But before it gets to that point, they do get their ducks in a row and get the charging documents up to the judge so that they can be advised by the judge and get a bond.
Okay, so what factors go into deciding on the bond?
Well, the bond is a consideration of what is the likelihood that the person is going to return for court, and are they a danger to the community, and how serious are the charges against them? And so when you're looking at setting a bond, obviously the bond from first-degree sexual assault is going to be considerably higher than the bond for a DUI. And it's just based on the charges, even if that person is completely innocent of the sexual assault. So the judge takes into consideration the seriousness. Then they take into consideration the person's criminal history. Have they been in trouble with the law before? Say, for instance, if they're in on a DUI, have they had previous DUI arrests? And then they look at, if they've been in trouble before, have they ever failed to appear for court? Now, if the person has failed to appear, then the bond is going to be increased. That is, they'll have to post more bond to get out. And then finally, the court considers how dangerous is this person to the community if the allegations are true. And so if you have somebody, again, that's in on, say, like shoplifting, well, danger to the community is pretty low. I mean, you could consider the retail store as part of the community, but is the average person walking down the street or driving their vehicle on the road, are they in danger if this person is out and about? And so those are the factors that the court takes into consideration when they determine your bond and the conditions that go along with your bond.
Okay, so we're still only in the first 72 hours, ideally. And is this a time when a person should have an attorney helping them, or can they do all this on their own?
They can, and some people have to do this on their own because they just haven't had the opportunity to hire an attorney yet. But we can definitely help at this phase. As we spoke about before, if they're taking more than 72 hours to get in front of the judge, we can call the prosecutor and light a fire under them. And if they're going before the judge and need bond, we can also talk to the prosecutor about an agreed upon bond amount and agreed upon conditions. So conditions for release might be that they have no contact with the alleged victim and that they not be allowed to go back to their house, say if the incident occurred at their house with their wife. They may have a condition where they're not allowed to drink. They may have a condition where they're not allowed to leave the county or the state. They may have to actually go through testing, that is pre-trial release testing. Maybe they'll need to test for drugs or alcohol, just depending on what they're accused of. So yes, we can help eliminate some of these conditions, and just the fact that they've hired an attorney shows that they intend to not flee, and so we can potentially get the amount, that is the money they have to post, significantly reduced.
Wow. Okay. So is this at the point now when there's going to be some sort of hearing, and is this different for misdemeanor versus felony?
Yes. So an initial appearance on a misdemeanor, if they go before the judge, they can plead guilty or not guilty on a misdemeanor because they're in that court where the whole entire case will be handled. Now, if it's a felony, they are not in the same court where the whole entire case will be handled. And all they can do is have the judge advise them of the charges and then get a bond. So both places you can get a bond, or you will get a bond, and you can actually plead guilty if it's a misdemeanor, which we obviously do not recommend doing since you haven't had a chance to review the evidence. And in a felony, they're not allowed to plead guilty because the case will actually potentially go in front of a district court judge or a felony judge.
Okay, so are we at the point here in the process where now the next thing that happens is a trial, or is there something before that?
Well, no, we are not there yet. And so we're just to the point where they've pled not guilty or they've gotten a bond. Now, if it's a felony, the next thing that they're going to have to appear for is called a preliminary hearing. And that hearing is set very quickly since the person is in custody. So they get that next hearing within 10 days of going before the judge. Now, that is because they might not be able to afford to bond out, and that person shouldn't sit there if the state can't prove their case. And so at the preliminary hearing, the state puts on evidence that establishes what's called probable cause for the charge. Now, probable cause is about here, and proof beyond a reasonable doubt is way up here. And so the state just has to put on some evidence that the crime was committed and that the person accused, the defendant, committed it. And it's a small hurdle that they have to get over, but sometimes they cannot get over that hurdle. And so that's why if they can't afford bond, they need to be released if the state can't at least prove probable cause early in the case.
Okay, so if they do prove probable cause, now we're getting ready for trial, right?
Yes, so we may be on track for trial. We will get a new court date, that is an arraignment. So in a felony case, remember they didn't get to plead guilty or not guilty at the initial appearance. That's because that's saved for the arraignment in a felony case. And so in a felony case, we will go before the judge, and unless, by some miracle we want to plead guilty at this point, which very rarely happens, we will plead not guilty, and we will get all of the evidence, all of the investigation. Everything will be sent over to us so that we can review it and decide whether or not to go to trial. And so once that not guilty plea is entered, whether it's at the initial appearance for the misdemeanor or the arraignment for the felony, then the court gives us deadlines for filing motions and gives the state deadlines for giving us the evidence.
So it sounds to me like at this point, it's up to the defendant whether they want to go to trial, because the defendant has the power at this point to say, I give up, I'm guilty, and everything's done. But if they say, no, I'm going to keep defending, or the lawyer says that, they're in control of whether it goes to trial or not and gets put in front of a jury, right?
A lot of times, I would say 9 out of 10 times, yes, the defendant makes the decision whether or not to go to trial. And that's based on a lot of things. And so what we look at is the evidence and how was the investigation conducted, how credible are the witnesses. Did law enforcement violate any of the client's rights? Could we get some of that evidence suppressed? Can we visit with the prosecutor about how terrible their witnesses are? And so, we look at all of the evidence very, very carefully, and we try to get an offer from the prosecutor that the client would be happy with. Now, if we can't do that, and the prosecutor just doesn't see the flaws in their case, we can file motions, ask the judge to look at it, get that evidence suppressed, and force the state to dismiss the case. That is definitely a great outcome for the client. Unfortunately, there's not always issues with the investigation. Now, there may not be issues with the investigation, but the witnesses might be terrible. And again, if we think that we can attack the witnesses' credibility and get the case in front of a jury dismissed, then we will seriously consider setting it for a trial.
Okay, so now we're at that point. All of that stuff has been done, and that's taken a while, and we're at the point where you're preparing for trial.
Yes, and so when we prepare for trial, always there is, you need to weigh the risk versus the benefit of going to trial. And so if we feel that the state's going to have a hard time proving their case, or if we think that maybe the state will be able to prove their case, but we will have a defense which will allow the jury to find the client not guilty, then we start preparing and going down that road to trial. Now, trial's always risky no matter how strong your case is. You're always leaving your fate into the hands of 12 people on a jury and, the ability of the prosecutor and how the witnesses will show up and how they will testify. Now, we may think one thing's going to happen and a completely different thing can happen at trial. And so there's always a risk of going to trial, but sometimes it's definitely the best route to take.
Well, it sounds like if you're at that point and you have been the attorney this entire time, there's a really good chance of a good outcome. So if someone needs you to lead them through all of this, how do they get in touch with you?
Sure, we'll include a link in the description where they can call, text, or chat with a member of my team anytime, day or night. Here at Just Criminal Law, we know you only get one shot at justice, so make yours count.